Almost 200 years ago, two parties contracted to transport goods with a ship. One party accused the other of breaching the contract, and they both made waves in court in Glaholm versus Hays. Glaholm owned a ship, the Pomona. Hays handled freight. Glaholm and Hays formed a charter party, which is a contract between a shipowner and another to use the ship to transport cargo. In the contract, all parties mutually agreed that the Pomona would sail from England to Trieste on the Adriatic Sea. In Trieste, Hays would load cargo onto the Pomona, and the Pomona would head back to the United Kingdom. The contract allowed a set period for the trip and included a clause that read, quote, "The vessel to sail from England on or before the 4th day of February next," unquote. The February 4th clause was unique because most of the other clauses before and after the February 4th clause began with the word "that," using phrases like "that the cargo" and "that the freight." The clause regarding February 4th didn't begin with the word "that." The Pomona didn't depart England on February 4th. Instead, it left almost 20 days later. When the Pomona arrived in Trieste, neither Hays nor anyone working for him was with cargo for the ship. Glaholm filed an assumpsit, meaning a claim for breach of contract, against Hays. But Hays argued that the clause requiring the Pomona to leave England by February 4th was a condition precedent. And since the Pomona left late, Hays didn't have to perform on the contract and didn't owe Glaholm any damages. The court decided whether Hays breached.